Environmental Law Update Web Conference. In this program, we address what companies need to know before, during, and after an EPA inspection. I'd like to take a moment to introduce our program speakers for today. First, we have Mark Timke. Mark is a partner with Foley and Lardner in our Milwaukee office. His practice encompasses all major environmental programs, including hazardous waste, Superfund, the Clean Air Act, air toxins, and wastewater. Mark has been involved in Superfund matters ranging from landfills, municipal well fields, and the investigation and cleanup of river and harbor sediment remediation areas, representation of discharges on issues involving water toxins, limitations, and the development of a detailed anti-degradation policy, and work on several major air enforcement actions. Second, we have Gary Rovner. Gary is a partner with Foley and Lardner in our Chicago office. His practice focuses on all aspects of environmental law, including related litigation and regulatory compliance. Gary's client services combine a thorough, substantive knowledge of federal and state environmental regulatory schemes with extensive experience in general and environmental litigation. Lastly, we have Sarah Slack. Sarah is a senior counsel with Foley and Lardner in our Madison office. She divides her time between remediation and redevelopment work, environmental compliance counseling, transactions, and environmental litigation. Sarah has extensive experience on the cutting edge of the Clean Air Act, Clean Water Act, Superfund, and RCRA enforcement, as well as citizen suit litigation, settlement strategies, and related cost recovery, insurance coverage, and indemnity disputes. Before I turn the presentation over to our speakers, I'd like to go over a few housekeeping items. Today's program will last approximately 1 hour, followed by a short question and answer session. We encourage you to submit written questions during the program. Please type your question into the Q&A widget open on the left-hand side of your screen. We will respond to written questions at the end of the program, time permitting. The webcast console you are looking at can be completely customized. You can resize or move any of the windows that you have open, including maximizing the PowerPoint presentation on your screen. If you experience technical difficulties during the program, please visit the webcast help guide by clicking on the Help widget below the presentation window, which is designated with a question mark icon. The PowerPoint presentation will be available on our website at foley.com in the next few days, or you can get a copy of the slides in the resource list widget. As a reminder, today's program is being recorded and will also be available on Foley's website in the next few days. We will apply for CLE credit after the web conference. If you did not supply your CLE information upon registration, please send an email to Ellie Kemeter at ekemmeter@foley.com. To be eligible for CLE, you will need to log into the On24 session and answer a polling question during the program. As a final note, those seeking Kansas, New York, and New Jersey CLE credit are required to complete the attorney affirmation form in addition to the polling question that will appear during the program. A 4-digit code will be announced during the presentation. Please email the form to Ellie Kemeter at ekemmeter@foley.com immediately following the program. And now I'd like to turn the presentation over to Gary Rovner.
Thanks, Ellie, for the introduction, and good morning, good afternoon, everybody. I hope the vast majority of you, at least those of you east of the Mississippi River, are attending this webinar under a down blanket. The plus of a cold day like this is that one would suspect that the inspection teams wouldn't want to go inspect the back 40 of anybody's facilities on a day like today. So sit back and relax and learn a little bit about inspections. Again, my name is Gary Rovner. I'm here in Foley's Chicago office. My job today is just to set the table for my colleagues Sarah and Mark. I'm going to talk more broadly about recent EPA compliance and enforcement history and initiatives and kind of who's in the crosshairs and what EPA has really been focusing on before we get into the nitty-gritty of what to do when they come to focus on you, if they do. So starting off, I mean, we're in an environment where both the regulated industries and the enforcers are facing sort of a set of unique compliance and enforcement challenges. For the regulated entities, you know, in more recent history, with our emerging from a recession, a lot of our clients and folks in the regulated environment have experienced reductions in staffing, dismantling of their corporate environmental groups, and reduced resources to deal with compliance. In that context, a lot of states, funds that would help with cleanup and compliance are drying up or being eliminated altogether. And generally, we're seeing a movement away from internal audits and controls and towards ISO 14000 type standards. For EPA, their challenges are no secret, much publicized budget fights, shrinking budgets, in the context of the significant new regulatory programs and the increased complexity of those permitting programs under the current administration, reduces resources across the board and requires more focused monitoring and more focused inspections with results that we'll talk about. Every 3 years, the EPA sets its enforcement initiatives and goals. The current enforcement initiatives sort of evolved from prior initiatives under the Obama administration. No secret for most of us. Air pollution remains a big topic, particularly from large sources and cutting hazardous air pollutants and air toxics, hazardous chemicals, reducing pollution from mineral processing and so forth. Water enforcement, particularly with respect to PHWs, contaminated stormwater, and with a particular focus on combined animal feed operations and animal wastes going to surface waters. And of course, with the rise of energy extraction, newer energy extraction entrance into the marketplace, a focus on fracking and then historic mining practices as well. Just uploaded for you to peruse just an excerpt from what EPA posts on their website, documenting where their enforcement actions have taken place and by category. You can play around with this on the site if you like. There's just some interesting information you can divine from it in terms of geographic focus and particular targeted industry focus. Certainly you see clusters around urban areas. You see clusters of air and chemical enforcement in particular states, if you look at Michigan and Wisconsin and so forth. Just really for your information and to see where funds and enforcement focus has been going and trending. Here's another slide that EPA likes to talk about, in terms of their enforcement results, measured in terms of pollution reduced in pounds. I don't put this on there to make any particular point other than to focus you on the idea that when EPA trumpets its successes, they like to talk in terms of these numbers, which just goes to the point that larger sources where they can show bang for the buck and real results in terms of these numerical success stories gives you an idea of who might be more in the crosshairs than others. They keep track of the number of case initiations and conclusions, and outwardly facing to the citizenry, brag in these terms, and I think that's information that's useful to all of you. Another interesting trend in terms of administrative and civil judicial penalties, you can see a rather remarkable spike. This is another metric by which EPA measures its success, and you see a slight increase and then quite a spike in fiscal 13 in terms of overall penalties assessed by EPA against the regulated community. In this case, a lot of that might be attributable to just a couple of cases, but that being said, again, outwardly facing towards the citizenry, EPA is looking for these kinds of splashy enforcements with settlements that really show the regulated community paying the price for under certain enforcement regimes. In that context, it's interesting to see that the overall number of case initiations is actually trending downward. So when you see the spike of dollars in compared to the number of actual enforcement actions, you see, again, the continuing trend towards looking towards bigger sources and bigger payouts at the end of the day. And doing more with less. So transitioning for a moment to criminal enforcement, an interesting illustrative quote from EPA Region 4. Many cases that could have gone civilly, have gone civilly that could easily have gone criminally if we'd had the resources to investigate and prosecute. Sometimes it's just luck. Again, the point being, oftentimes there's not a large difference between what could be enforced civilly versus criminally, other than resources available to EPA at the time and who they choose to target. Keep in mind that environmental laws have both civil and most environmental laws have civil and criminal provisions. What changes something to a criminal violation is really just based on whether something was knowing, and it's from a legal perspective a very broad definition of what knowing might be. So criminal liability is out there just because you don't necessarily see as many criminal enforcement matters doesn't mean EPA couldn't. No surprise here, what underlies the decision to go criminally versus civilly, most times EPA would see either persistent noncompliance by a facility or a company, active concealment or obvious concealment of a violation, or what appears to be obvious manipulation or erroneous reporting of test results, as might be required under a permit or other regulatory scheme. Not surprisingly, EPA also keeps track of the number of criminal enforcements. You see numbers that are actually fairly similar to the number of civil cases, with actually 278 defendants charged in fiscal 2013. Again, continuing the theme, reduced budgets does mean focus on efficiency, and again, we see more of a trend towards inspections of larger facilities where criminal matters are concerned. A couple of significant cases that really did show the spike in penalties, executive recycling and Walmart. And keep in mind, another point of fact, EPA keeps a fugitive list, those who are being pursued under the long arm of the law, and EPA has its own enforcement personnel to track fugitives. And they keep those folks online. There's some interest. If you want to lose an afternoon, it's an interesting thing to go see. Another factor to keep in mind in terms of trends and things to be aware of for everyone on this call, DOJ does favor pursuing individuals in criminal matters. The Chief of Environmental Crimes Unit at US DOJ outwardly said, I will never trade individual liability for corporate liability. Obviously, making an example of an individual is seen as more of a deterrent, and it certainly should be seen that way. Just an example of a posted wanted poster for an environmental crimes, an alleged environmental criminal who was actually a fugitive from justice in Mexico. Similar spike, just thought illustrative for you all to see, criminal enforcement value of fines and court-ordered projects. Obviously, another large spike in fiscal 2013. Again, largely attributable to a couple of cases, but still showing the overall trend towards doing more with less and getting splashier and significant financial settlements. Cases resulting in more than $4.5 billion in combined penalties and $1.1 billion in civil penalties in fiscal 2013. Yes, a lot of that was attributable to Deepwater Horizon, but even absent the $3.7 billion going to that, you still see that's a pretty large number compared to historical criminal cases. So the takeaways, with ever-shrinking budgets, EPA is certainly figuring out how to do more with less. Bigger bang for the buck. Even though fewer inspections, we're seeing them at larger facilities for more publicity, more deterrence, and big criminal cases against famed and reputable companies. What are the sources of environmental investigations and enforcement? No surprise here for most. Certainly compliance reports under permitting regimes and periodic certifications, when those are easy to review, and in those cases, when we talk about bang for the buck, when a company is certifying, emissions to be X and they turn out not to be X, the case is already made. So with limited resources, those are really, really fertile sources for EPA to come after regulated facilities. EPA wants permit limits to have its compliance methods and compliance checks. Certainly inspections, which we'll be talking about momentarily, notwithstanding budget reductions. A brief aside about states and state inspections, we are seeing a trend in reduced state inspections. Certainly in my home state of Illinois, with our budget issues and with our new governor as of 3 weeks ago, we expect to see inspections to be further reduced. Nevertheless, EPA is trying to take up that slack with, again, the target enforcement inspections I've talked about. Always a good source, complaints by neighbors, former current employees, And obviously, any spill release reporting always can often trigger an inspection as a follow-up. A brief note before I hand off about EPA's Environmental Justice Initiative. This is something that EPA's had on its radar since the early mid-'90s under the Clinton administration, the concept of environmental justice. Broadly, that has always meant something like targeting enforcement actions, EPA targeting and enforcing its enforcement actions in overburdened communities, defined as communities experiencing disproportionate environmental or public health impacts from environmental pollution. In practice, that often means facilities sited near to inner cities, populations that are particularly burdened by having with proximity to heavy emitting industrial facilities, much more likely to be, certainly under this administration, factored into whether or not an enforcement decision is to be taken and what type of enforcement. Those are usually high value and high publicity type matters. Environmental justice we are seeing it increasingly incorporated into enforcement decisions and priorities and as a part of enforcement remedies and cleanup remedies under Superfund cases. So with that, I will hand off to the meat of the presentation to my partner and colleague Sarah Slack in our Madison office, who's going to talk about inspections before, during, and after. Sarah?
Thanks. Yep. Thanks, Gary. Good morning and good afternoon, everyone. As Gary indicated, my name is Sarah Slack, and I get to talk to you today about the meat and potatoes of the presentation, which is some best practices to consider before, during, and after inspection. So as a preliminary matter, and I know Gary touched on this, but just again to think about how inspections are initiated is kind of a starting point. Inspections can be the result of just an annual inspection. Either an inspector may come to your facility every year, or there may be some element of your permit that requires an annual inspection. Another trigger for inspections can be if there's a complaint, either by an employee or a third party. So for instance, if a neighbor complains of odor or noise, that can trigger an inspection. Or if there's an incident at a facility, including a release that's reported, or if there's a permit violation. So for instance, if on your DMRs you submit something and you had a couple of exceedances, maybe that's enough to have the inspector decide to make a visit to your facility. Another way that inspections are initiated is for those types of businesses or processes that are in the EPA's enforcement initiative categories that Gary spoke about earlier. And last, and certainly not least, inspections sometimes happen just because. Maybe the inspector was driving past your facility and noticed you had a new sign and thought they'd stop by and just take a look around. Maybe they just needed something to fill an afternoon on their way to or from someplace. Maybe they just decided they liked the name of a new business that's in a location. Sometimes there are no explanations for why an inspection can occur. So next I just wanted to talk about kind of the scope of inspections. As Gary indicated as well, inspections can occur either on a federal or a state level. So they can be either EPA or state folks who are knocking on your door. And they can be both planned and surprised. An inspector may call you up on Monday and say, Friday, I'd like to come and look at this process. Or they may just knock on your door on Friday afternoon and say, hey, I'd like to take a look at your hazardous waste storage area. The scope of an inspection also can vary greatly. It can be a single facility or it can be a multi-facility inspection. So to the extent that a company may have facilities, either multiple facilities in the same city or state, or even across states, we've seen this as well. EPA may target a certain company and do multi-facility inspections over the course of a certain time period. In addition, the scope can vary depending on whether or not EPA just wants to look at records or at samples. And then they can also vary if they're focused or if they're multimedia. So a focused inspection would be one that, for instance, is just going to look at, the inspector's just going to look at your air emissions stuff. Or a multimedia one may be one where you have an inspector or multiple inspectors who come in and want to look at your air, your water, and your waste. So companies, we generally suggest as a best practice that companies have an inspection plan and have procedures in place for when these inspectors knock on your door. Those should be periodically reviewed and updated. As we all know, environmental laws are constantly changing, and something that's been sitting on your shelf for 5 years may not reflect what would be a best practice currently with respect to an inspection. And just with respect to something to be thoughtful about is with shifting assignments and furloughs, you need to make sure that you're providing coverage for potential inspections. So to the extent that, that you have someone who's assigned to manage this, make sure that there are multiple layers of folks who are able to help with this because maybe someone's off or on vacation or something like that. So before the inspection, best practices to think about. Obviously, the first and most obvious is to just make sure your company is in compliance with all permits, laws, and regulations, which I know is much easier said than done. However, it is a best practice to try to make sure that your company is ready for an inspector to knock on your door at any moment. Something to consider is to have an internal audit program whereby you could confirm that a facility is in compliance with its permits and then with environmental laws in general. And another thing to consider is to consider taking that a step further and maybe even getting a third-party audit. Another thing to consider before inspections occur is to make sure that you have any documents that have been created by in-house or outside counsel in a separate file or file drawer. And this is because those documents are going to be subject to the attorney-client privilege. And to the extent that they may convey legal advice, you want to make sure that those are segregated from, for instance, your waste manifest, so that an inspector doesn't open up a folder and start flipping through and inadvertently come across a piece of attorney-client privileged information that thereby would waive the privilege. Just something to think about with respect to segregating these materials. To the extent that an attorney has prepared a document, but then it has been filed or submitted to an agency or a court, it is no longer privileged. At that point, it becomes a matter of public record. So, and then with respect to a company's attorneys, another thing that's good to do is just to have the company's attorney's name and telephone number easily accessible. If EPA knocks on your door and they're surprising you with a multi-facility, multimedia inspection, you probably are going to want to call in your attorney just to have them available as a resource. So it's good to have that information available. And finally, and what I'm going to talk about in more detail momentarily, is we recommend that you implement a facility plan, an inspection plan that you keep current and utilize for inspections. So inspection plans. Again, these elements are what we recommend should be included in an inspection plan, and that includes making sure that you have a primary and alternate contact at the facility. Again, if John Smith is your EHS person at a facility, but he's going to be on vacation for 2 weeks in Puerto Vallarta, you need to make sure that somebody is available in the event that it's during those 2 weeks that an inspector knocks on your door. The inspection plan should also make sure to identify the location of any pertinent records. This is especially true for records that are required to be maintained by your permit. If an inspector would like to see those, it looks a lot better if you could take them right to them rather than fumbling down trying to figure out where exactly those are. Again, the inspection plan should also include procedures for notifying your corporate environmental staff and your attorneys to the extent that you may want to call those folks in. And this is particularly relevant at smaller facilities that may not have an EHS person on site. So for smaller facilities, your inspection plan contact may be the site manager or maybe a shift leader or supervisor. But so in those cases in particular, you may want to make sure that they contact the corporate environmental staff at the onset of an inspection. And then the other thing to consider is to make sure your inspection plan includes the locations in your facility where environmental monitoring is conducted. So an example of this is, for example, stormwater monitoring. Perhaps you may have a permit that would require you to annually monitor your stormwater discharges. An inspector may want to see those monitoring points and may also want to possibly collect samples. So just making sure that that information is in the inspection manual as well. Additional items to include in an inspection plan is to make sure you have the location of the inspection-related equipment. So that would include cameras, sample bottles, or video recorders. Inspectors have gotten into the modern age, and they very frequently show up with cameras. They want to take pictures of processes, sample bottles. They want to take samples, or even with video recorders to record how a process is being done. So it's a best practice to make sure you have those on site as well to duplicate what they're doing. You should also make sure that the inspection plan includes any health and safety procedures for inspectors. So if your facility requires personal protective equipment, that there is something specific in the inspection plan to make sure that that the contact who's leading the inspector through thinks about making sure the inspector complies with that. And then finally, another thing that should be included is trade secret protection. So if you have a process at your facility that is a trade secret, you want to make sure that it's very clear in your inspection plan what that process is, because you're going to want to alert the inspector to that and make sure that you limit any or prevent any pictures or videos that they may take of that process. All right, and then these next three things I'm going to talk about in more detail with respect to these being in your inspection plan, but that's procedures for meeting inspectors, the conduct during the inspection, and post-inspection procedures. All right, so meeting the inspector. Again, it's best practice to make sure your plan designates a contact person, and then you should also assign each inspector who shows up with a company employee. So to the extent that maybe it's just one inspector, you may only need one person, but if someone shows up and they've got a couple of people, or particularly if it's going to be a multimedia inspection, there may be several folks. It's the best practice to make sure that there's a company employee assigned to each of those individuals. That way, if the inspectors end up separating during the course of the inspection or talking to different people, you've always got someone from the company who's listening in and is aware of the information that the inspector is viewing or gathering. Another thing to do when you're meeting the inspector is it's completely appropriate to ask them to check their credentials if they're not known. Now, this might not apply to the extent that you may have an inspector who you've known for the last 10 years and he comes every year and you know him, you don't need to check his credentials. But if it's someone unknown, it is completely appropriate to ask to check their credentials. And another thing to consider when you're meeting the inspector is to just talk with them about what the scope of the inspection is. This is a brief process, and it can really make for a much more efficient inspection for both you and the inspector. So the types of information you want to understand is, what equipment or processes are they planning to look at? What records do they want to look at? Are they going to take pictures and samples and videos? Because again, if all of a sudden they pull out a camera in the middle of your facility and you say, oh, geez, if I'd known you were going to take pictures, I would have brought my camera, and then you have to run back. It can delay the inspection. So it's just best to know up front what they're planning to do. All right, and so I wanted to take a moment here and just briefly talk about unplanned inspections and potential delays or search warrants. So to the extent that there is an unplanned inspection, you can always, again, we recommend that you contact your corporate environmental and legal folks kind of as a starting point. But then you can coordinate with them and see whether the company might want to consider having outside counsel or consultants be present for any part of the inspection. And then you can determine if requesting a search warrant or delay is appropriate. Now, under most environmental laws, federal and state agencies have a lot of discretion to review facilities to confirm that they're in compliance with environmental laws and permits that they have been issued. So turning an inspector away, they will most likely be able to come back with a search warrant and get into your facility. So absent a really good reason for delay, we don't suggest that you consider that you do delay an inspection. But there can be good reasons for delay. And some of those include, if you do need to obtain legal or corporate support. So maybe an example of this is if an inspector shows up and wants to do some air sampling, but you don't have folks on hand who would be able to do that, you could ask them to maybe come back tomorrow so that you can make sure to have your folks available to also take samples as well, things like that. Another good reason maybe if an outside consultant has expertise that will assist the inspector, maybe you just put in a new line and the consultant helps you to get that permitted, and the facility folks are still understanding it, still getting up to speed. That consultant can have information that would be very beneficial to both the facility and the inspector, and their presence would be good. Another thing to consider is if there are other pending enforcement actions. If you are currently undergoing an enforcement proceeding, you may want to ask them to have a warrant before they come onto your facility. There can be other extenuating circumstances, but those, again, are very rare. And you need to be aware and thoughtful about the tone you set if you do decide to turn someone away, because it just takes the inspection to kind of the next level and makes it more adversarial. So then getting back to the pre-inspection discussions with the inspector, there are certain things that we suggest you reach agreements about in your conversations. So for instance, if they do plan to take samples, you want to make sure that you let them know that you'd like to take split samples. Another thing to make sure that they're aware of is if there is any trade secret processes. Maybe they want to come and see your new line, but it's a trade secret. And so you're happy to show this to them. They have the right to inspect it, but you're going to request that they not take any pictures that would end up being a matter of public record. And then another thing to think about is whether an exit interview will be conducted. Again, this is an opportunity to just go back through with the inspector the results of the inspection, but framing it and letting them know up front that you'd like it just helps manage their expectations. You also want to make sure you know what areas of the facility they want to look at, what records they want to look at, and again, if they're going to be taking any photos or videos. You want to make sure that you have a discussion with them about the health and safety procedures so that they know and understand what those are. And then you want to let them know that at the end of the inspection, you'd like to obtain a copy of the inspection report, either at the very end, or if they could provide one once they get back to their office. So with respect to the review of the health and safety procedures, make sure that you have equipment on site for an inspector to use. So if your facility requires a hard hat or eye protection, make sure that you have that available so that an inspector can get into your facility and view what they need to view and still comply with the health and safety procedures. And then it's also best to keep notes of the pre-inspection discussions. And this is going to be important as you go through the inspection so that you can see if there are any deviations that may occur. So during the inspection, it's very important to treat the inspector like any visitor, cordially and professionally. Now, being overly friendly or being curt and rude could both send the wrong tone. So, the inspector is a professional who's there to do a job, and, it's best to remember that and just treat them like they're any other professional who's entering your business. With respect to managing the inspection and interacting with the inspector, you should make sure to answer the inspector's questions and only go to the locations requested by the inspector. Again, if the inspector's there to see your new line, you don't need to take him the long way through to everything. Take him right to that point so that he can see that. You're going to want to also limit the company employees that discuss matters with the inspector. If the inspector has a specific question about something, make sure you try to find the employee who has the best knowledge about that so that the inspector can get that from one person. And then you're going to write down and review any problems or questions that the inspector identifies during the course of the inspection and what corrective actions you have taken or will take. So, to the extent that you're in the middle of a waste inspection and an inspector says, oh, that's not dated, that's probably something that you can fix on the spot. And so, to the extent that you can correct it right away, it's always a good idea. And then you're going to want to start and end each day with a meeting of company personnel who participated in the inspection. And this is just your company folks. And this is just to make sure everybody's on the same page and understands what happened over the course of the day and can share experiences and, say, oh, yes, so-and-so looked at this and so-and-so looked at that, and just make sure everybody knows what's going on. Now, with respect to statements made to an inspector, here, one of the ways I like to frame this for clients is to kind of think of an inspection almost a little bit like a deposition. You're required to be truthful. You shouldn't make any false statements. Those may end up being subject to criminal sanction. And there are certain things that you shouldn't do, just like in a deposition. You shouldn't volunteer information, only answer the questions that are asked. And this can lead to some awkward silences. But again, remember that you're there to just provide them with the information they need in order to make their inspection. And you should be friendly and cordial, but you don't need to fill silence or space. Another thing that's important not to do is do not speculate. You can always arrange to get information to the inspector after the inspection is completed. It is much better to do that than to speculate and state something incorrectly and then have to go back to the inspector a couple of days later and say, oh, I need to correct that information I provided you. That can end up making it look like either the person that was providing the information isn't actually competent in it, or it can look like maybe the facility was trying to misrepresent something. Either way, it's just better not to speculate and to arrange to get the information later. This may seem obvious, but I wanted to make sure that put in here, do not whine or complain. The inspector's there doing a job, and it will just set the wrong tone for the inspection if whining or complaining occurs. Another thing not to do is don't argue that the facility has been doing it a certain way for years, and the last inspector never said anything about it, so it must be fine. A couple points on this. First of all, a new inspector may disagree with the prior inspector about whether or not something is in compliance, and they have the right to do so. Second of all, giving that information or making that statement provides the inspector with the information that the facility may have been out of compliance for a longer period of time and may make the inspector consider giving violations for historic noncompliance. Most environmental laws have a 5-year statute of limitations, and so to the extent that they could go back and issue an NOV for 5 years, that's just an opportunity to do so, making statements like that. Another thing not to do is don't argue that you weren't aware that your facility had to comply with environmental regulations. Everyone is required to know what regulations apply to their facility and to be in compliance with them. And making that, again, will just set the wrong tone and put the inspectors off. Now, this is an important one that is particularly relevant to the extent that a lawyer is not present in inspections, and that's making sure that the folks that are going through the inspection with the inspector don't make any legal admissions. So, for example, don't agree with an inspector that an alleged noncompliance is a violation. There may be exceptions to this. For instance, if there's, if something's not labeled and you can quickly label that, that's fine. But to the extent that an inspector looks at a process and says, you're not monitoring that correctly, or your monitoring equipment isn't functioning correctly, you should never admit that that's the case. You should just make note of it and say that you'll follow up with it. And then another comment that turns inspectors off is when people make statements about how paperwork violations aren't that important. They're not a big deal. For agency staff, paperwork is one of the most important ways that they ensure compliance. So in their opinion, paperwork is very important. So again, making statements like, oh, it's not a big deal that we're not in compliance with our paperwork requirements, that again sets the wrong tone, makes them think that you're maybe a little flip about your compliance requirements, and we'll just put them off. And to the extent that there may be an inspector who gets aggressive, or if the questions just start to be really demanding or pointed, or they're asking you the same question over and over, trying to get you to admit something that you're not willing to do, be prepared to stop answering and seek legal assistance. It is completely within your rights to tell the inspector that you need some time to contact legal counsel in order to answer their questions. Again, it may be that this statement in and of itself resets the mood and the inspector will back off, or if not, then you have the opportunity to contact your legal counsel for going forward. Also during the inspection, to the extent that an inspector wants to interview an employee, employees have a choice of whether or not they want to cooperate. Obviously, generally to the extent that the employer is being inspected and they would like them to comply, they can, but they do have the option not to. And inspectors don't have the right to interfere with work. So they don't have the right to stop a line and pull folks off of it in order to ask them questions. They can coordinate with whoever their contact is to arrange for a time and a place that is convenient to the employee when they could speak with them for a short period of time, perhaps at the end of their shift or on a break or something like that. If the inspector asks for documents during the course of the inspection, it's a best practice to ask them, for a written request. Now, obviously, this doesn't necessarily apply if you're required to maintain records under your permit. But if they ask for something outside of the scope of your permit, then what you can say is to say, I'd like that in writing. First, that does a couple of things. First of all, it allows you the opportunity to go back and review your files and make sure you get them all of the information that they're requesting instead of trying to scramble and put it together and give it to them at that time. Second of all, and this gets to the second item here, it allows you the opportunity to review those documents with counsel and make sure that you understand what information you're providing them. So if sampling is going to occur, one of the things that's very important is to make sure that quality assurance and quality control procedures are followed. And again, this is a situation in which whoever is responsible for sampling at the facility, whether it be someone on site or an outside consultant, where it may be a best practice to have those folks present during the sampling. That way they can note any discrepancies in the quality assurance and control that may occur during sampling. And they can also make sure to take duplicates, again, preferably split samples of all of the samples that are collected. One thing to consider is if you have a process that they're sampling and it's a complicated sampling process, think about videotaping it. That way you have a record of what's done, and if there are any issues with the sampling or any anomalies in the results, you can check back and confirm whether or not the sampling procedures were properly followed. And this gets to photos and videos. You should also make sure to take duplicates of all the photos or videos that the inspector takes, and from the same angle. And part of this is as the next bullet indicates, to make sure that there isn't any trade secret information that is captured by the photograph. Again, once the inspector takes that, if they print it out and they put that in their file, it can become subject to the public record. There are potential ways that you can try to get that protected by trade secret, but to the extent that you can try to prevent it up front, it's just easier to do so. And then the other thing is that this enables you to make sure you know exactly what they're looking at and referring to. Maybe the inspector gets back to his office and is looking back through his materials and says, oh, I took this picture, picture 13, and it's showing that there's a violation of this process. And you pull up your picture 13 and you say, oh, no, you're thinking of process A. This is process B. And then you can make sure to help the inspector understand what they're seeing. All right, and so during the inspection, the other thing to do is to document it. And a best practice to consider for this is if you have someone who's going to be leading the inspection or being the contact of the inspector, maybe to have a second person who's following along taking notes, so that one person can focus just on interacting with the inspector and the other can focus on documenting it. And so make sure to document again the locations and the equipment that are looked at, what questions the inspector asks and how they're answered, any follow-up items that the inspector asks you to do, any statements that the inspector makes about noncompliance. So if they say, oh, it looks like you're not sampling correctly or something of that nature, make sure to make a note of that. Document the sampling procedures that occur. Again, take copies of photos and videos. For trade secret information, make sure that you mark any issues with that. So if the inspector takes the picture and it captures a trade secret process, make sure to make a note of that so that if you need to go back and file a request that be maintained as trade secret, you do so if they're unwilling to, for some reason, not take that photo. And then keep copies of all the documents that the inspector provides to you. And then another thing to do is to make note of any noncompliance the inspector has, either with the agreed-upon procedures that you had at the beginning or with health and safety requirements. So maybe at the beginning the inspector says, oh, I want to look at processes A and B. And you get through and you've looked at A and B, and the inspector says, I'd like to see process C. And you can say, oh, well, I thought you only wanted to look at A and B. And maybe that reminds them to say, oh, yeah, you're right, I don't need to see process C today. Or maybe you go on to look at process C. Maybe they do want to see it, and they just forgot to mention it earlier. But it at least helps you keep track of what was agreed to and what the status is. All right, so then once the inspection is completed, again, you can ask the inspector if they could have a brief exit interview if possible. It's best to have framed this up at the beginning so that it's not a surprise to them and they don't think they can just run out the door. There's a lot of value to this both to the inspector and to the facility itself. It gives the facility an opportunity to ask what violations may have been identified, and then also to see if there's any additional information the inspector may want. And that's actually a benefit to the inspector as well, just to give them a moment to say, I didn't think of document Z, but if you could provide me with a copy of that, that would be very helpful. With respect to doing a post-inspection report, again, we suggest that as a best practice. And that should include information about who was involved, not just the names of the inspectors, but also the folks at the facility who were involved. It should also include the agreements reached with the inspector and the results of those. It should include what procedures were followed, any follow-up information that was requested. A number of these things we've already talked about, but one thing I just want to mention again is, make sure that it's documented what sampling and chain of custody is done so that you can confirm any deviations from that. And for the inspection report, it's also really helpful to have a summary of the exit interview. All right, so then after the inspection, it's best to submit the post-inspection report to the corporate environmental and legal staff under an attorney-client privilege communication so that they can review it and coordinate with the facility on any corrective actions that need to be taken. And any corrective actions should be implemented as soon as possible. And the government should be notified in writing by certified mail with return receipt requested of any changes or corrections that the facility makes to improve its environmental compliance. Again, there's always an opportunity if an inspector leaves and you can make a quick fix to something by, making sure all of the drums are in the secondary containment or something of that nature, then that's an easy, quick fix. You take a picture of it, you send it into them, and maybe they use that information to decide not to issue a notice of violation because you've corrected already. Maybe not, but it is a best practice, and it does show that the facility is committed to compliance and to quickly responding to any potential issues. Also, after the inspection, you should, to the extent that there's a large issue that's identified, you should make sure to continuously update the government as to the status of how you're remedying the problem. Paperwork violations should be corrected as soon as possible, even if the paperwork needs to be prepared from scratch. And an example of this is if an inspector says, oh, that's a TRI chemical and you haven't been reporting it. Then you have an opportunity to go back and prepare your TRI reports for the prior years, 5 years into the past, and submit those and get that issue corrected. Now, even though it may have been for historic reporting years, you should still date any documents that are created with the date that they're prepared and with the name of the person who completed the document. And then they should be signed by, obviously, a corporate official that has authority to do so. And then once all of the compliance issues have been resolved, it's another best practice to just send a letter documenting that to the agency and make sure that they confirm that the compliance issues have been resolved. So as a final thing, I just wanted to take a moment and just talk about some best practice considerations for inspections. As Gary had indicated, there are a wide variety of potential environmental liabilities. Different statutes, things can go criminally or civilly. And then, enforcement at large facilities is on the rise, and the consequences of noncompliance can be really severe. Penalties can be very steep. Reductions or changes in processes can have effects on facilities, operations. So compliance upfront is definitely a best practice. And, we definitely suggest that companies need to be proactive in making sure that they're in compliance. And part of that is preparing, maintaining, and implementing an inspection plan, like we've discussed. With respect to inspections, an ounce of prevention is definitely worth a pound of cure, and we hope we've provided you with some information to help you on in that process. With that, I will turn it over to my colleague, Mark Timke, and Mark's going to talk about some next-generation enforcement and some new things that agencies are doing with that. Mark?
Thank you, Sarah. And we're going to move from some of the more detail that Sarah gave you, and I really want to stress the importance of it because we have used those tools in real-life inspection situations, and the advice that Sarah's gone through was very helpful in resolving some of the enforcement issues that came up very favorably for the clients involved. So I would say those are very helpful hints. With respect to moving on with the next generation of enforcement, I just want to note that I see a couple of attendees here from the sunny state of California. I was out there giving a talk earlier this week, and I guess I maybe have to question my judgment as to whether I give the talk in the frozen north today or should have stayed at the San Diego Convention Center and enjoyed looking out over the wonderful ocean and 70-degree weather. But here I am back in Milwaukee, Wisconsin, so we'll talk through the next generation of enforcement efforts. Both Gary and Sarah have mentioned that the more traditional enforcement tools, these tend to be rather resource intensive. EPA or the states which are doing inspections will tend to target facilities. These can be based on size or whatever particular program seems to be hot in the environmental enforcement topic, and we've certainly seen waves of certain types of enforcement efforts. They can be inspection focused, certainly all the MAX standards on the air side. Whenever one of those has been in effect for a year or two, you'll see an inspection team going out and discussing inspections with facilities. But it takes a fair amount of time to both plan the inspection, to target the facilities, sift through the data that's collected, and then at least at the federal level you end up with focused information 114 requests, for example, in the air area, and they get just as focused responses back from facilities to those. information requests, which really is pre-litigation discovery, and it's very resource intensive for both sides. While effective, and Gary went through some of the settlements and enforcement achievements that the agency has had success with, we do see these budgets being reduced both at the federal and state level, and we've certainly seen a shift in some states with a new political emphasis more on being cooperative toward industry and less on the enforcement side. So you see decreases in enforcement occurring in many places throughout the country. In order to really deal with some of this, the Office of Enforcement and Compliance Assurance, I always love that name, Enforcement and Compliance Assurance always has kind of a nice tone until they show up at your facility, is really trying to rethink compliance and rethink the efforts to try and reduce the amount of intensity of their resources being put to it and to find new ways to track compliance on facilities. These efforts were built into the strategic plan of the agency. It hasn't gotten a lot of attention. It's gotten some in the trade press, but it's really something to take a look at. It's been out there for a couple of years floating around, and it certainly is on the key item on the list of Cynthia Giles, the head of OECA at EPA. It's built on 5, they call them interlocking components. I've listed them here. We'll talk about those in a little more detail to give you a flavor of where the agency is going with a lot of their enforcement efforts in the future. Here is some resource tools that you might want to look at. There's a very interesting book put up by the Environmental Law Institute on next-gen enforcement. There are some very useful insights in that. We do know that OECA is providing assistance to cooperative states on employing these next-gen concepts, and just to show you the currency of it, there's even a next-gen symposium going on next month at the George Washington Law School, and a number of OECA staff and management will be there. And before we get into the detail, I'm going to turn it over to Ellie Kementer to talk about getting CLE credit for those of you who need to get CLE credit for this webinar.
Thank you, Mark. So at this time, I'm going to read the CLE code for this program. If you are in need of CLE credit today, please enter this 4-digit code into the poll question on the screen after it's announced and press the Submit button. The code is UEFQ. Again, that's the letter U as in uncle, the letter E as in Eddie, the letter F as in Frank, and the letter Q as in Quincy. UEFQ. Again, if you are seeking CLE credit for the session, please complete the polling question by entering the code that was just announced. The polling question will remain open briefly. And for those of you seeking Kansas, New York, and New Jersey CLE credit, in addition to the polling question, you will need to complete the attorney affirmation form and return it immediately following the program. And a copy of that form can be found in the resource list widget. Again, if you have not entered the CLE code, please do so now.
All right. Are we ready to continue, Ellie?
Yep, the poll can now be closed.
Okay. All right, we've done our government compliance on the CLE credit for us lawyers. And moving on then to next generation in terms of the detail of what this program is going to look like and the 5 components. We're going to spend a brief time on looking at it. The first step that they have is trying to build compliance into the rules and permit conditions themselves and try and develop rules and permit strategies that are self-implementing. An example that's cited in the literature is one that deals with the mobile side, and that's auto emission regulation. This is an interesting system where the auto engine manufacturer is required to certify and install pollution controls on equipment. The manufacturer becomes almost the police for downstream assemblers of the engines that go into vehicles, because it's the manufacturer that's making the certification and the manufacturer which has direct enforcement responsibility with the agency. So it certainly puts another layer of enforcement on the private side into the program so that EPA can focus its resources on a select group of manufacturers. And this is cited by Cynthia Giles as a as a mode that they would like to achieve in other regulatory programs. An example is they're looking at a proposed rule for on the energy extraction side where you'd be required to buy and use EPA pre-certified air pollution control equipment. So it's not that you can just go out and buy any of the equipment. You have to buy the certified equipment. The manufacturer you buy it from reports to EPA who purchased it to certify to the agency that it was purchased. There's some compliance checks on the fact that the equipment was purchased and installed, and then electronic data reporting will flow from this equipment. This is viewed as a way of trying to, again, limit the inspections that have to be done, limit the amount of resources that go into the checking on facilities. We're also seeing a movement and discussion of requiring the use of, again, EPA-approved continuous emission monitors for stack emissions and other types of these electronic monitoring devices, which will be pre-EPA approved, and then you'd certify that it's installed, and then you set up an electronic data reporting system back to a state or federal agency. We're also seeing, and the agency is relying on this new equipment that's out there on emissions detection technology, and certainly been at conferences over the last 2 to 3 years, seen a significant growth in innovation, the technology, the ability to use these handheld small devices. They're set to detect specific chemicals and emissions. We don't need the large monitoring stations that we used to have before that were very expensive to operate and maintain. And so there's tending to be a movement toward fence line monitoring. It's illustrated in a recent hazardous air pollution rule for refineries where this new fence line approach is coming to the fore. The fence line monitoring is being required. There's also some new regulatory thresholds approach tied to this monitoring, and if the monitoring is showing a threshold action level is being exceeded, which is not a regulatory level but it's an action level, then the facility would have to undertake certain types of corrective actions. If you still have exceedances after the corrective action, then you need to put a correction to plan into EPA, and if you don't implement the plan, then you have a violation. This would all be built into the rule, and that would translate then into requirements built into your permit. So again, these kinds of methods which are creating the ability to monitor and to impose action by the facility right away without the need for an inspection or an enforcement action. EPA also has some interesting projects. One's called Green Village. If you haven't seen it, you might want to take a look at some of the things on the website about it. They're actually doing a test facility of putting sensors in park benches to report on ambient conditions from air monitoring standpoint. We're also seeing that there's real-time water quality monitoring buoys that can be put into rivers that can report ambient data near manufacturing or facilities that discharge. One of the practical aspects of this, when you get real-time monitoring, it really starts to translate into lower emissions, because with new action targets being set, even though they may not be regulatory targets, but they're action targets, operators will tend to lower the emissions to reach this new bar. And if you're in a facility with process variation, you would want to keep your variation on the upper end below whatever that action bar is. So in a sense, it's pushing down your emission levels to avoid having to trigger these kind of action levels, so leading to lower emissions. Transparency is another focus of NextGen. Basically, improve public access through electronic means. A recent blog off of the American College of Environmental Lawyers indicated that this is here to stay. A lot of us, I'm sure, are all familiar with the old ECHO web page that EPA had. They took it down earlier this year. They're starting to bring it back in terms of various media. AIR is not up there yet, but if you take a look at it, The data presentation is much better. The explanations are much better. You can actually track enforcement settlements on facilities and see where they stand. You can track compliance orders. Much greater transparency than was on the prior ECHO web page, and all of this is available to the public. So with the more data available, the more tracking of compliance that's taking place on the web, of course, more interest by NGO entities as to how facilities are doing and what's happening with their compliance efforts. And there's some innovative enforcement as the other tool that's coming to the fore. There's a directive out from Cynthia Giles to use these kind of tools in new enforcements. This directive just came out in January and wants them included in the civil and administrative settlements. These kinds of tools you're going to see are things that have been used in some cases, but we're starting to see more of it being used. Certainly advanced monitoring. Again, fence line monitoring. It was used in the BP Whiting case, which is a refinery case in Indiana, where monitors are put on the fence line to detect various types of emissions. Again, much stricter enforcement for compliance with the facility. A tool we've seen in some settlements in the past, but certainly coming to the fore more on the next gen effort, and that's independent verification of compliance with the settlement. So using third-party auditors to report back either to the agency or to a court as to how compliance is being achieved with the particular settlement or the court order that occurred in the case. It can deal with pollution control installation and operation. There have been some efforts at CAFO corrective actions, and again, one of the cases where these kind of third-party verification techniques were incorporated. So we're going to see that kind of an effort continue. In addition, affected communities will be also provided with data on the compliance with these settlement obligations, and not necessarily through ECHO, but more of a direct community data arrangement so that it can be available to the affected areas. I think some of the practical considerations of all of this as we see this coming to the fore is you really need to understand as we move from paper to electronics to fence line monitoring to data that's coming off of EPA certified monitors, potentially going straight to agencies. What type of data recording is taking place? What type of monitors are being used? What's the accuracy of those monitors? They may be certified by EPA, but how comfortable are you with the accuracy of those monitors? Data security. We all know about data security from the news and all the reports of hacking that's been taking place. What's your data security with respect to this information, and how comfortable are you with data security with respect to the government? How much of this information, as we start to require electronic reporting, becomes confidential information for your facility as we start to track specific chemicals or monitor those with handheld devices? All things to think about, and whether or not you need to take steps to protect those data security or confidentiality of this information. Rulemaking and permits. Certainly being involved with next-gen proposals. Look at these rules that are going to be set with new target levels that require actions. See how this is going to play out into permits. Again, these are action levels that aren't tied necessarily to specific regulatory emission levels, but they're showing up in rules and they're showing up in permits. With respect to data transparency, you need to know what the public knows. So if you're not looking at these kind of public websites and you're not looking at what kind of information is there, which may or may not be accurate, the public is seeing that, and you need to either take steps to correct it or know what's there with respect to questions you may receive or with respect to potential third-party actions that may occur. And as Sarah said, of course, compliance. That's always the best case as we go through this, and hopefully all of these ideas and thoughts that we've been able to transmit today have been useful and helpful for you as you undertake the task that you have to keep facilities in compliance. With that, I will turn it over for questions that, Ellie, that we would handle for people.
Great. So I know we're running a little long on time, but we do want to answer the couple questions that we got during the presentation. So this first one I'm going to direct to Sarah. Can you comment on electronic documents versus hard copies? Are hard copies preferred?
Thanks, Ellie. And the short answer to that question is no. Hard copies are not preferred. You know, Mark talked about how a number of monitoring mechanisms these days are done electronically, and you know, a lot is being done electronically. To the extent that you are allowed to maintain documents in an electronic format, it is completely acceptable, and agencies and inspectors will be comfortable with reviewing documents in that fashion. So.
Thanks, Sarah. This next question I'm going to direct towards Mark. Shouldn't a non-disclosure agreement be required if the inspector is not an EPA employee, but rather a third-party contractor hired by the agency?
Right. Sometimes the EPA uses third-party contractors to do certain types of inspections, and typically, at least we have seen, that the third-party contractor will show up with an agreement that is in place dealing with potential non-disclosure of information, and you need to take a look at that. Negotiating that on the spot in an inspection setting is oftentimes difficult, and if there are items in such an agreement where you do have specific problems or issues with it, certainly you want to get the attorneys involved at that point in time early in the inspection process, be polite about it, but say that we need to discuss before the inspection can go forward with respect to how confidential information is treated by the third-party contractor.
Thanks, Mark. And finally, I'm going to direct this last question back to Sarah. Isn't EPA, as the employer, responsible under OSHA for ensuring its inspectors have all the required PPE and safety training needed for doing their jobs?
Thanks again, Ellie. Yes, EPA is responsible as the employer. However, you know, employers are responsible for visitors to their facilities. So, although inspectors are arguably doing their jobs, so they should be trained and everything should be the responsibility of EPA, it is again just a best practice to make sure that any visitor, whether it be an inspector or someone coming in to look at a line or something like that, that they have PPE available to them. So definitely a best practice.
Thanks, Sarah. So that was our last question. So we invite you to contact any of today's speakers if you have additional questions or would like more information on their particular topics. And then this wraps up our web conference today. So just as a reminder, today's program is being recorded and will be available on Foley's website in the next few days. If you have any questions regarding CLE for this program, please contact Ellie Kemeter at ekemmeter@foley.com. And at the conclusion of this program, a questionnaire will appear. Please take a minute or two to give us your feedback about the presentation today. It's important for us to know your thoughts and helps us shape our programs going forward. Thank you again for your participation.